Hi, this is Victor. I'm going to discuss the order of proceedings in a felony case. After arrest, the first thing that's going to happen is the arraignment. The arraignment on the complaint. There's a couple of different types of charging documents, and you can read about them here, or maybe it was in this video, or that video. One of the videos talks about the different types of charging documents, but the first one in a felony case is a complaint. At the arraignment, the defendant will be advised of the general nature of the charges against him and will be asked if he has enough money to afford an attorney, and if not, an attorney will be appointed. Sometimes the attorney will immediately conflict out by saying that they're unable to take the case, and then it will be assigned to a different attorney who may or may not be present. After the arraignment on the complaint, the next step in the proceedings is generally a conference of some type. The conference may be called a pre-preliminary hearing, a preliminary hearing setting conference, a scheduling conference. This step can repeat multiple times, but at these conferences, the defendant is generally given an offer. You're charged with burglary. If you plead guilty, we will let you plead to second-degree burglary. You're charged with a crime carrying 8 years in prison. If you plead guilty or no contest, we'll let you serve 2 years in prison, or maybe we'll even put you on probation. Conferences are a time for offers, a time for the attorneys to confer. The prosecution will confer with the defense, and sometimes the judge will be involved in these conferences, sometimes not. The next step is called the preliminary hearing or the indictment. Most of the time it's the preliminary hearing. At the preliminary hearing, the prosecution will put on some evidence to show that the defendant committed the crime. If the judge agrees that there's some evidence that the defendant committed the crime, the defendant will be bound over. The next step is what's called the arraignment on the information. Notice I've already said arraignment once. The first time was the arraignment on the complaint. The next time is the arraignment on the information. The information is the document that is a product of the preliminary hearing. It's what the judge believed that the defendant was guilty of. I'm oversimplifying this, I know. You can Google all of this, but it is the second arraignment is the arraignment on the information. The next step is generally pretrial motions. This is the time that your attorney is going to bring, for example, a motion to suppress, a motion to dismiss for insufficient evidence. There's discovery motions. There's a limited number of motions that can be brought at this stage of the proceedings, but that number is not very limited. There are a lot of motions that can be brought, but the standard ones are a continuance, asking for more time, a suppression motion, asking that evidence be suppressed, a discovery motion, asking that more evidence be produced, or a motion to dismiss. Another common pretrial motion is what's called a pitches motion, or a motion to discover evidence of officer misconduct. After motions have been heard, and sometimes there will be multiple motion states, comes another conference. Generally speaking, this is going to be referred to as a readiness conference, and this is where the attorneys announce whether or not they're ready for trial. And sometimes there will be multiple readiness conferences because the attorneys won't be ready. They need further investigation. They need a further motions date. They need something that's going to delay the proceedings. But these are readiness conferences. The next step is the actual trial. This is where the defendant finally gets to have his jury. He finally gets to have his day in court. At the trial, witnesses will be called, evidence will be taken, and the jury will return a verdict if possible. If the defendant is found guilty, the next step and final step is sentencing. At sentencing, the defendant will be sentenced. He will be told what he's going to have to do to atone for his crime. That's the basic criminal procedure in felony cases. Thank you.